Welcome to Meet the Candidates 2022, a voter education program brought to you by the Shakopee Chamber of Commerce. My name is Tim Zunker, and I'm the president with the Shakopee Chamber and Visitors Bureau. Our hope is that these candidate interviews and profiles will help you, the voter, understand your choices when it comes to the 2022 elections. We ask voters to arm themselves with the information necessary to make educated choices and to make casting your vote a priority. Please visit the Shakopee Chamber website at shakopee.org to find out more information about the upcoming elections. And now at this time, I'd like to introduce Allen Andersen, who is running for Scott County Attorney. Allen, thank you for joining me today.
Thanks for having me today, Tim. I appreciate it.
Yeah, please tell us a little bit about yourself.
Thanks. I'd love to. So I'm a lifelong Scott County resident. I moved to Shakopee when I was about 2 years old with my family from a small Iowa farming community. And then I lived in the county all through high school. I bounced around between Shakopee, Savage, and Prior Lake. Actually graduated from Burnsville High School because I lived in the part of Savage that was Burnsville School District. But really, I've grown up in Scott County, and it's where I've spent most of my life. After I graduated from Burnsville High School, I spent 4 years on active duty in the Marine Corps. My job was as a truck driver. Motor transport operator is a technical term, but I was really just a truck driver. And most of my time was spent, I was stationed in Iwakuni, Japan, which is on the mainland. It's about 45 minutes south of Hiroshima. I did a lot of humanitarian assistance out there. We responded to typhoons and other natural disasters in the Philippines and Thailand, throughout all of Southeast Asia. And we also responded to hostile aggression from North Korea by responding to South Korea on a few occasions as well. So those were my primary responsibilities when I was in the military. So I was active duty for 4 years and then got out after that, honorable discharge. After that, I decided to attend the University of Minnesota, where I got my undergraduate degree in political science and sociology of law, criminology, and deviance. And that was really where my passion for the law kind of kicked in. I started to learn about why people committed crimes, what led to deviant behavior, and what methods there were out there to try to correct and solve that problem. So I really got into that in undergrad and then chose to go to the University of St. Thomas for law school. While I was at the University of St. Thomas, I also completed a master's degree in public policy. So I got my JD and my master's at the same time. And really going to school at St. Thomas formed my belief for what the criminal justice system should be. St. Thomas is a Catholic law school, and I'm not personally Catholic, but I really did resonate with their message of Catholic social justice, which is essentially teaching all of the law students that the skills and abilities that you earn through your education should be used to better the public good. And that's how they frame up all their teachings at that school, and that really had made an impact on me. I knew going into law school that I'd always wanted to be a prosecutor. But that was a really unique experience for me to learn an ethical style of prosecution from my professors there. So I ended up parlaying that into some legal jobs. I worked at the Minneapolis City Attorney's Office as a prosecutor. I worked at the Scott County Public Defender's Office briefly, making bail arguments for criminal defendants. And then I eventually was hired at the Scott County Attorney's Office. During my time there, I was there for a little over 4 years. And during my time there, I was primarily a juvenile prosecutor. I handled juvenile cases. So I carried a caseload that ranged from minor consumption tickets all the way up through felony sex crimes. And that was what I did for the most time when I was in Scott County. But I also carried an adult misdemeanor caseload for a period of time in which I prosecuted DWIs, domestic assaults, other offenses of that nature. But really the most exciting and the most rewarding thing that I did when I worked at Scott County was help start the Scott County Veterans Treatment Court. I helped write the federal grant application. I brought together all the interested parties in the county. We created a policy and procedure manual. And ultimately we created the Scott County Vets Court, which is still running as of today. So that's currently now I am representing people in Hennepin County. I do not work at the Hennepin County Attorney's Office. I represent people facing eviction, people who are indigent and who are facing eviction. So I'm kind of like a civil public defender now, trying to help people. Obviously, once COVID expired, the COVID moratorium protections expired, the number of evictions in the state skyrocketed. And so it's been a real interesting experience to represent those people who are in danger of losing their housing. So that's what I'm doing currently while I'm running for this position. And yeah, I'm hoping to come back and make a difference in my community because this is where I grew up. This is the office that I kind of cut my teeth in. And it would mean a lot to me to be able to come back here and make a difference in my community.
Great. Thank you, Allen. So that brings us to the question of why are you running for Scott County Attorney?
Yeah, I guess I kind of jumped the gun a little bit there, but as I mentioned, this is my hometown. So this is where I've spent the vast majority of my life when I wasn't off in the military or off in school. And so this community really does mean a lot to me. And when I got to work in the Veterans Court program, I was also assigned as the prosecutor from the county attorney's office, working in the Vets Court program and actually carrying a caseload of those defendants. And I got to see the impact that a program like that can have on somebody, where you intervene early, where you provide them with resources and services that they're in need of, and where you supervise them much better than they are on standard probation. And when you can do those things, you can really change someone's life. And if you can change the life of somebody who's committing crime, you can generally get them to stop committing crime. So we had participants who would come into Vets Court who had been addicted to methamphetamine for years and years and years, who hadn't held a job in years, who hadn't seen their family in years. And they're just they're in a bad spot. And when you're in a bad spot, that's when you tend to start committing crimes. And I got to witness how those people were brought into the program and they went to chemical dependency treatment, oftentimes more than once before it was actually effective. They went to therapy and addressed whatever mental health issues they were struggling with. They completed their education. They got jobs. They reestablished connections with their family. They got involved in their communities again. And then at the end of all that, they got to graduate from the program, and they got to keep a criminal conviction off their record, and they got to leave the stigma of being a criminal defendant behind them and reintegrate back into their community. And that was a really powerful experience for me to be able to work with those people and see how those programs can really make a difference in their lives and how it can benefit society as a whole if you can get that person back to where they were before they fell into trouble. And so what I wanted to do, what I've really taken up as my personal mission, is to expand that access to justice that the veterans have right now to anybody and everybody who's involved in the criminal justice system and is in need of those sorts of services and programs. Scott County already had a veterans treatment court, or a drug treatment court, before veterans treatment court was created. So they've kind of gone in the right direction there, but I would like to expand it to anybody who has a qualifying mental health or chemical dependency diagnosis. You still need a diagnosis from a professional for one of those two things. But essentially, if you have one of those two issues that's causing you to commit crime, and we can get you the resources on the front end that's going to address those problems, then you're going to stop committing crime, the caseload is going to be reduced, and the public is going to be much safer. And so that's my goal, is I would like to take that philosophy that's used in a very small scale treatment court model right now and expand that to the justice system wide. And then the other benefit you get from that is not only are you helping those defendants in need of it, but then you're saving resources because you're not continually prosecuting the same people and the same offenses over and over and over again and not making any change. You're not prosecuting those cases anymore, so you can rededicate those resources to do a better job of investigating and prosecuting violent crimes. Particularly in this county, I think that they need to do a better job of investigating and prosecuting domestic assault crimes, which was a large part of my caseload. And so I think if you can take the resources away from those individuals who are not a threat to public safety, who are not likely to recidivate, who are simply in need of some help, you get them out, and then you rededicate those resources to violent crimes. That solves a lot of problems for a lot of people, and that's what I would like to do if I'm elected.
Great, thank you. So currently there are programs in place in Scott County to help prevent crime and reduce recidivism, including treatment court, choose not to use, take it to the box, and the worthless check program. What works with these programs? And if you were elected Scott County Attorney, would you add or change any of the current programs?
Yeah, well, as you may have got already, I'm a huge fan of treatment courts. I think that, frankly, treatment courts and diversion programs are the future of the criminal justice system. And Scott County so far has done a decent job of kind of dipping their toes in that water. The drug court has been around for 5 or 6 years, I believe, and has had a lot of success. And the Veterans Treatment Court has been around a shorter period of time, but has already shown a lot of success. It's had some successful graduates. It's had very little recidivism, if any. And so these programs are shown to work. But my belief is that Scott County simply has been too hesitant to adopt more effective, broader programs that have the same impact and outcome as these do. These programs work because they address the root cause of why people commit crimes. And the root cause of why somebody commits a crime is that they lack access to some sort of basic need, whether that's housing, whether that's employment, whether that's food, whether that's you're chemically addicted to a substance and you can't function unless you have that substance in your system. There's some sort of basic need there that's not being fulfilled for that individual. And so they turn to an illegal activity in order to fulfill whatever that need may be. And what these programs do is address those basic needs. The standard criminal justice system that's been around as long as we can remember has never cared about that. Except maybe at a sentencing portion, you get an opportunity to tell the judge your story and they take that into consideration about what your punishment is. But it's never really been the concern on the front end of law enforcement or prosecutors or the judges, at least determining the guilt on the front end. It's never really been important to consider the reason the person was committing the crime in the first place. The courts were a place to determine the facts of what happened and whether a person was guilty or innocent of a crime. And I believe that those days are behind us. I believe that prosecutors have a responsibility to do justice. It's not a prosecutor's job to seek a conviction in each and every case that comes across their desk. It's their job to ensure that justice is done properly on each and every case that they see. And what these treatment courts do and what these diversion programs do is allow an opportunity for that person to address that cause that's causing them to commit the crime, and then giving them an opportunity to show that they can remain law-abiding after that. Most of these programs require you to do some sort of programming on the front end, even the diversion programs, to do some sort of class or something like that on the front end. And then you have to go a certain period of time without getting in any sort of trouble before that actually is dismissed or comes off your record or whatever the situation is. So they're great programs because they address the root cause of why people are committing crimes. And then they give them an opportunity to show that they can follow the law once they've had an opportunity to be educated. So I'm a huge fan of those programs. And if elected, I would push to expand them significantly. I know at the moment that the Scott County Human Services Department has interest in starting a mental health court. So I would certainly be in favor of that. I was a juvenile prosecutor as a long time, as I mentioned, so I would be in favor of starting a juvenile drug court. As of now, if you're under the age of 18 and you get a drug charge in Scott County, you can't participate in drug court. I know there's some interest in the county of exploring the possibility of a DWI court. And then I also think it would be important to explore the possibility of a tribal court because of the Native American community that's in Scott County. So those are all courts that I know have some level of interest within the county. And I think that because I am a big believer in those kinds of programs, I would fight hard to try to expand that. And when I say fight hard, it's not just me saying something. I've shown that I can make these things happen. I wrote the federal grant application. I helped put together the policy and procedure manuals. I've done these things in the past, and I'm confident that if I'm elected, that I can get these new programs into existence again.
Great. Thank you, Allen. The county recently allocated ARPA funds to improve the court backlog. What do you see as long-term solutions to help keep the court's backlog low?
Yeah, court backlog is a huge issue that I think everyone is dealing with right now. This is not an issue exclusive to Scott County. In my current role representing housing court defendants, we have seen a significant increase where housing court cases are higher than they've ever been, particularly before pre-pandemic. And so it's really a problem that everyone is trying to find a solution to, and frankly, no one is really doing a very good job of yet. I worked at the county attorney's office here in Scott County during COVID when the courts were shut down. And it was an interesting experience because it was something that had really never happened before, that no one had any understanding of how long it was going to last, of what the implications were going to be, or just how to handle cases in the meantime, because it's the Minnesota Supreme Court is the one who decides whether the courts are open or not during an emergency such as that. And so it's really out of the hands of the local policymakers about how to move cases, because if the courts aren't open, you can't move cases. So local policymakers were stuck in a bit of a difficult position because there just really wasn't options out there to pursue. But I will say, looking back at that time period, I was really proud of being a part of the juvenile justice partners at the time, because in the juvenile justice field, we switched to Zoom hearings much sooner than most of the state did, frankly. Well before our adult divisions did in Scott County, and well before many other counties switched in general. And I credit the group of people that we were working with, myself and another coworker from my office. the public defender's office, Scott County Community Corrections, the judges in Scott County. We all came together and determined that it was going to most negatively impact the juvenile cases to not be processed. Because the idea of punishing somebody for a crime is that you want to change their behavior. And in order to change someone's behavior, you need to get that interaction to them as soon as possible. And if you're not getting an interaction as soon as possible, or as close in time as possible to when the action actually occurred, it's unlikely to change the behavior. So if you're getting a juvenile who is charged with a 5th degree assault because they get in a fight in school and they don't come into court until 8 months later, when you impose a sanction on them that 8 months later, that's not going to have much impact on their behavior. But if you can get them in sooner and they can get an immediate consequence from that, that's how you really change behavior. So we felt it was really important to make sure that those hearings were happening and that there wasn't this lag that was occurring, particularly with adult jury trials. And so I was really proud to be a part of a group who made sure that our policy changed rapidly with the situation so that we could continue to process cases through the juvenile division. So now to expand that system-wide to try to address that for everybody, I think in particular in Scott County, the biggest thing that the county attorney's office can do to help the backlog is to increase efficiency within the county attorney's office. And when I refer to that, I mostly refer to the amount of turnover that has occurred in that office in the last year and a half or so. I don't know the exact number of people who have left, but I know that it's much higher than surrounding offices, and I know that it's much higher than it should be. And I know that other people who work within the county have taken notice of the amount of people who have left recently. And that causes a big problem because when you have a prosecutor who is assigned a caseload, for example, when I was working in the misdemeanor division, my caseload was approximately 400 cases at any one time. Now, not all those are active cases. Some of them are in warrant status. Some of them are in other statuses that you're not necessarily actively working on them. But any one time, I had approximately 400 cases in my caseload. When an attorney leaves to go somewhere else, or support staff leaves to go somewhere else, or a victim witness coordinator leaves to go somewhere else, all the cases that they have assigned to them need to be transferred to somebody else. So in the meantime, before someone new is hired, all those cases are divvied up between people who already have big caseloads. And so they're overworked and their cases are generally underprepared. In the meantime, if you get somebody hired, once that person comes in, they need to be trained before they can start working on their own caseload. So you're dedicating resources there without any positive outcome. And then in addition to that person being trained, you have a senior employee who's generally having to do the training of the younger employee. And that takes away from the senior employee's ability to do work that they need to get done. And just as important as that lack of resources is the ability of a prosecutor to be familiar with a case. When a prosecutor leaves and a case is unresolved, that gets passed on to another prosecutor who is obviously not going to be as familiar with that file when they first take it over as the previous prosecutor was. And this is a real problem right now because the way the system had worked in Scott County, at least when I had worked here most recently, was that there was a priority list for trials, and it started with the serious felonies, and then the non-serious misdemeanors were lowest priority. And if they didn't get to the low priority cases, they would just get kicked to a new date. And so all the misdemeanor domestic assaults and DWIs and all those kind of cases where people were out of custody continued to get kicked down the road because the felony cases were prioritized. And in the meantime, as they get kicked down the road, the prosecutor and the support staff and the victim advocate continually get swapped out. And so these cases are never seen by the same person more than multiple times. And this creates issues for a lot of people. I spoke with a victim recently who was subpoenaed to testify in a domestic assault trial. And the charges were ultimately dismissed. And although she expressed to me that she very much believed the individual was guilty of the offense, she was ultimately relieved to not have to come in and testify at that trial. Not because she was afraid to testify necessarily, but because she had never met the prosecutor and the victim witness advocate who was assigned to her file. She had met a prosecutor and a victim witness advocate initially when they had their first hearing, but that person had switched multiple times throughout that file being prosecuted. And so that witness was at a point where she would rather have the charges that she believed were valid be dismissed than have to go and enter that courtroom unprepared because she didn't know who the prosecutor and the victim advocate on her case were going to be. And so I think that if you have that sort of turnover in an office and you have that inefficiency in prosecuting those files, all that's going to do is add to the backlog of cases. There's a lot of things that are out of control of the county attorney's office and are determined by the bench in particular about how things are run. But I do believe that maintaining steady employment and making sure the turnover is significantly reduced would be a great way for the county attorney's office to increase efficiency. That's kind of a big scale thing that obviously needs to be implemented over time. It's something that can be started immediately, but it's something that is going to take a while to implement, particularly as far as the culture goes. But if you wanted to address the issue immediately, I think a good plan would also be to create we call it a task force to identify a particular set of cases that cause a big backload. And those cases are generally misdemeanor and below offenses that are scheduled for an arraignment hearing. Your arraignment hearing is your first appearance on a misdemeanor or below charge. So again, you're talking misdemeanor domestic assaults, thefts, DWIs, trespassing, and even traffic tickets, speeding, things like that. Very low-level offenses in the grand scheme of things. And those offenses are rarely, the domestic assault and the DWIs are reviewed by an attorney, but most of those other offenses are not reviewed by an attorney until that arraignment. It's a police officer who makes the determination whether or not they should issue a citation, and they make that determination on the spot. And then if they issue that person comes to court, and it's not until that arraignment hearing that an attorney actually looks at the file and determines whether there was a crime committed and whether the facts of that particular scenario meet a statute that can constitute a crime. And that's a prosecutor's job, not a police officer's job. But if that's not being done until the arraignment, that's not an efficient way to handle that. So it's certainly possible that officers can issue tickets that don't have a valid legal basis that a prosecutor is just going to dismiss at that arraignment stage anyway. So if you can identify those cases ahead of time and get them dismissed, that'll get them off the court's calendar ahead of time. Additionally, a lot of those very low-level offenses, the trespassings, the petty thefts, the speeding tickets, most of those offenses resolve within a very small set of criteria. There are standard offers that are made based off of people's prior criminal history and then the facts of their case. And it's a very small set of outcomes there, and they apply to almost all those kinds of cases. So if you could proactively reach out to those defendants and try to resolve those cases of that nature within those parameters ahead of those hearings, you free up court calendars and you free up attorneys' times to be working on things that are more valuable. So I think there's a lot of ways to address it. I think, like I said, I'm certainly sympathetic that it was a challenge no one had ever faced before. But I think we're far enough out from when that occurred now that there need to be more active steps that are being taken to address that issue.
Great. Thank you. What are your views on the current bail system? What changes, if any, would you make?
So bail is, it's a tricky subject because I think essentially any piece of research that you're going to be able to find about cash bail is that it doesn't work. It's not an effective way to protect public safety. It's not an effective way to figure out who's going to appear for court and who's not. And it's not an effective way to decide who's a threat to public safety. Because just to distill it down into a very simple example, you could have an individual who's charged with a DWI and has to post, let's say they got a DWI and they hit and hurt somebody as well. That's very clearly a threat to public safety because there was a victim there who was injured. But if that individual is wealthy, if they have a full-time job and they have a stable housing environment, they have maybe some family who could pitch in and help them, chances are whatever the judge orders as a cash bail amount, they're going to be able to post either on their own with the help of family or through a bail bondsman. So that's an individual who is clearly a threat to public safety, but purely through monetary means is able to get out of jail while they await trial. On the other side of that, you could have somebody who is arrested for something as meaningless as a simple trespass. That's a misdemeanor level offense for which you could technically be arrested and held overnight. And if that individual went to go see a judge the next morning at a bail hearing and had a long list of other misdemeanor low-level offenses and then had a few prior failures to appear in court, the judge could put an extremely low bail amount on that individual, say $100 cash bail. But if that person doesn't have a single dollar to their name, they're going to have to sit in custody until either their case resolves or it goes to trial. And that's somebody who's clearly not a danger to society. A trespass is a much less serious offense than drinking and driving and hurting somebody. But the differences between those two people is that the wealthy person gets to get out and await their trial, and the poor person has to sit in jail. That has a lot of consequences for people. One of the primary consequences is that if you know you're going to be held in jail on a misdemeanor level offense and you want a trial on that, as I mentioned earlier, those misdemeanor trials, they don't happen right away. When I was at the county attorney's office, there were 1.5 to 2-year-old misdemeanor trials. And so the incentive for that person then is just to plead guilty to that offense because that's the quickest way to get out of jail. You'd rather plead guilty and just add one more misdemeanor to your record than have to sit there and wait until your trial date comes up. And it should be one of the most important roles of any county attorney's office to ensure that people who are not guilty are not convicted of offenses. So you don't want people to plead guilty to an offense just because they want to get out of jail. If they want to plead because they believe they're guilty, then they should certainly do that. But if they don't believe they're guilty, they should continue to play the process out. And that leads to other advantages, such as if you're not incarcerated, you can file motions where you can try to get evidence thrown out in your case. You can have other hearings such as that. The people that are in custody are disincentivized from doing that because, again, it just makes you wait longer and longer and longer. So the quality of representation that they get isn't as good either. So that's a long way of saying that the cash bail system doesn't work. We continue to rely on it because there hasn't yet been another good solution that has been tested to the point where people are comfortable abandoning their old ways. I think what does work most effectively is a combination of a bail and pretrial release conditions. And this is already sort of done now, particularly with a lot of DWI offenses. You'll have to have some sort of breathalyzer installed in your vehicle to make sure you're not drinking and driving. A lot of people who are in on drug offenses will have to take random drug tests. You can use ankle monitoring, GPS monitoring, house arrest. There are a lot of really good pretrial release tools that can be used to supervise people. And frankly, one of the new things that has worked extremely well throughout the state of Minnesota is that the judicial branches started using a messaging system where people can sign up to get reminders, text messages to their phone about court hearings. And then you have no real excuse for forgetting it because the court's texting you and saying, hey, make sure you show up tomorrow, you have court. And that's already been shown to increase people's appearances at court significantly. So I don't necessarily think it needs to be massive bail reform. I think that we need to identify that cash bail is not an effective method of doing anything we're trying to achieve. And then we need to start exploring other options like pretrial release conditions. What's important to notice about that is that those release conditions really fall in the hands of community corrections. They're the ones who have to provide the resources for that. They're the ones who actually have to do the monitoring of those conditions. And so solving this problem is not something the county attorney can do on his or her own. It's really something you have to collaborate with other agencies within the county to be successful with. And I'm confident that I can do that because I was able to work effectively with probation to start Veterans Treatment Court. And so I feel confident as well that we could work together in order to address that issue. And then finally, the other policy that I would like to advocate for as far as bail reform goes is called an unsecured bond or unsecured bail. And that works similarly to a regular bail. So if you go back to the trespassing defendant who had the $100 cash bail imposed on him, the way an unsecured bond would work is that instead of having to actually pay that $100 to get out of jail, the judge would still order that $100 on the front end and say, this is your bail amount. But then that person would be released with conditions and wouldn't have to pay the money up front. So that $100 wouldn't have to come out of his pocket up front. He'd be released with some conditions and a new court date. If he made all his court dates and didn't violate the release conditions, then at the end of his case, and when his case was concluded, that money would just go away. He would never have to owe it. On the flip side, if you were to violate a release condition or miss a court date, at that point, a warrant is issued for that person's arrest. They're brought back into custody, and then the bail amount can either be imposed at the same level or raised. So then that gentleman would eventually owe that $100 in bail if he were to violate his release conditions or miss a court date. So that still puts the financial incentive on the person to abide by release conditions and make future court appearances, but it doesn't keep people in jail who are poor and let people out who are wealthy, regardless of all the other circumstances that are going on. And then finally, at least when I worked in the county attorney's office, there was no standardized policy about how to make a bail recommendation. So at a bail hearing, the way it works is that a prosecutor will make an argument to the judge about what an appropriate bail amount will be. The defendant or their attorney will argue to the judge about what they think an appropriate amount will be, and then the judge is ultimately the one who makes the decision about what bail is set. At least when I worked in the county attorney's office, there were no guidelines about what recommendations to make for what offenses. It was really just learning from other attorneys in the office what they tended to recommend and then kind of copycatting what they did. But day one, if I were to come into office, I would work on instituting guidelines in the office based on a defendant's criminal history, based on the nature of the offense, and based on their prior failures to appear. There should be a central set of guidelines about bail requests, because then you remove individual and implicit bias from the situation, and you just have a guideline to work from. Of course, I would encourage the prosecutors to always take individual circumstances into account when necessary, but starting from that base gives everyone a good starting point, and that's something that needs to exist immediately.
Great, thank you. With the changes nationally towards decriminalization and legalization of marijuana, do you believe changes should be made in Scott County regarding prosecution of marijuana crimes?
Yeah, absolutely. From day one that I announced my candidacy, I've had a policy on my website that says I would instruct prosecutors to no longer prosecute any marijuana possession crimes within the county. It's important to note that that does not include distribution crimes. That does not include under the influence crimes, driving under the influence. That does not include if you commit some sort of violent offense and you also possess the drugs at the time or also possess marijuana at the time. Those are not what I'm referring to. I'm referring strictly to possession crimes, marijuana possession crimes. I would instruct prosecutors immediately in the office to stop prosecuting those offenses. And my reasoning for that is really twofold. First of all is I don't believe that a user of marijuana or frankly of drugs in general is a danger to public safety. Somebody who uses marijuana is making a decision that impacts their own personal health and well-being, but does not impact the public at all whatsoever. It's a prosecutor's primary responsibility to protect public safety. And prosecuting people who are making a personal choice that does not harm anyone else is not protecting public safety in my mind. In addition to that, if you're using resources to prosecute crimes that don't protect public safety, you're taking resources away from where they need to be. For example, violent crimes. As I mentioned earlier, I don't believe that domestic assaults are prosecuted to the level they should be in this county. And I believe very strongly that if you were to stop prosecuting marijuana crimes and other drug crimes, that you'd have a lot more resources left over to do a much better job of investigating and prosecuting violent crimes. In particular, in Scott County, they recently were found to have committed what's called a Brady violation, which means that one of the judges here in Scott County determined that the county attorney's office failed to disclose a crucial piece of evidence in a trial. It was a criminal sexual conduct trial. And it was a piece of evidence that included a statement from one of the victims. And the judge found that the county attorney's office failed to disclose that to the defense prior to the trial. And that's an imposition on someone's constitutional rights, could have led to that case being dismissed. And ultimately that individual was found not guilty of that offense. And if you're able to take prosecutors away from those offenses that are not a threat to public safety and let them reallocate their time and their efforts to working more and putting more effort into those violent crime files, issues like that don't occur. And I would also like to go so far as say that not only would I instruct prosecutors to not prosecute any marijuana possession crimes, I would also instruct prosecutors to only convict somebody of a drug possession crime once all other available alternatives have been explored. As I mentioned earlier, I don't believe it's a prosecutor's job to get a conviction on every single case that crosses their desk. I believe it's their job to do justice on every case that comes across. And if doing justice on a case is getting somebody the help that they need because they're chemically addicted, giving them an opportunity to do so because they're not a threat to public safety while they're working on that, getting them out of the system and then rededicating your resources to those violent crimes, that's positive for everybody. So I know the question in particular was geared toward marijuana, and I think that's probably because of the wave of decriminalization we've seen across the country, which is no doubt going to come to Minnesota at some point. And the vast majority of those decriminalization bills also have an expungement component, meaning that those are going to get taken off of people's records in the future. And in Minnesota right now, you can still be convicted of a felony for possessing THC oil. So you can get convicted of a drug felony, which means you can't get student loans, which means you can be barred from some housing, which means you can be barred from employment over a drug that does not cause any adverse health effects that can have actual medicinal value that causes no danger to public safety, and that most likely in the next few years the legislature is just going to expunge it off of your record anyway. So what's the point of burdening those people with felony drug convictions at this point? So in short, I would instruct prosecutors to stop prosecuting marijuana crime or possession crimes effective immediately. And I would encourage them all to adopt a treatment court model and only convict somebody of a drug crime, a drug possession crime, if they're unwilling or unable to do any further rehabilitation.
Great. Thank you, Allen. And we're going to roll question 6 into actually to your closing statement because you are asking. So question 6 is, why are you the best candidate for Scott County Attorney? So I'd like you to also give your final message and to the voters.
Yes, thank you. I appreciate the opportunity to do that. Excuse me. So I think I'm the best candidate for this position because from day one that I've announced my candidacy, I've been putting forward clear, articulable policy change that I would like to enact. My website has always had, ever since I announced my campaign, it's had my policy listed on there that I want to put in place. So anyone can go read and go understand and learn what it is I'm trying to do. And anybody that I've talked to at a fair or at a farmer's market or anything throughout this campaign, that's what they've gotten from me is this is the actual policy that I'm going to try to institute. I want you to vote for me because of the things I'm trying to do. And I also think I'm the best candidate for this job because not only do I have those ideas, but I've shown the ability to be able to implement them. Because I worked here in Scott County, because I know the other people in the agencies, because I've built really good, strong working relationships with the people who work in those agencies, because I've shown that I can do the legwork. I can write a federal grant application. I can present to the county board to get additional funding and to get their approval for programs. I can bring together partners. I can bring together judges, the sheriff's department, community corrections, the VA, the county service office. I can bring all those groups of people together to effectuate these changes. And these aren't the things I've said. I can say these are things that I've done, things that I've shown that I can do, and things that I want to continue to be able to do. So I was really proud of my opportunity to be able to be a prosecutor in the Scott County Attorney's Office. It was an opportunity. I got the opportunity to serve my country in the military, and I got an opportunity to serve my community in the county attorney's office. And what I really look forward to and what I would really like the opportunity to do is to continue to serve my community in that role, to ensure that the justice system continues to prosecute those who are a danger to public safety and to get out of the business of prosecuting those who don't need to be. And then ultimately, I think that will make a better, stronger community for everybody. So that would be my message is that my policies are strong. They're based in fact. They're based in science and research. And I've shown the ability to implement them in real life. So I would love the opportunity to be able to make that impact on my community.
Thank you, Allen. As a reminder, the views expressed in these interviews are those of the candidates, not those of the Chamber and Visitors Bureau. The Chamber is sponsoring these events as a service to the community and has gone to great lengths to ensure the objectivity. The Chamber does not endorse any candidate but seeks to provide you, the citizens and voters of Shakopee, with the information you need to make an informed choice. The Shakopee Chamber and Visitors Bureau extends a sincere thank you to the candidates. We appreciate your time and service to our community by running for office. You are performing an important service to us all. Again, thank you for joining us for this edition of Meet the Candidates 2022. Please join us September 29th at River Valley Church for our candidate forum. Please visit the Shakopee Chamber website at shakopee.org for more information. Thank you. Thank you, Allen.
Thanks, Tim.